Hi, everybody. Bill Prince again. We're going to continue on in our discussion of issues related to the employment environment of business. Specifically, we're going to be looking at Chapter 22, which deals with employment discrimination and some of the issues that spring from that. One of the key pieces of legislation that impacts the law relating to the employer-employee relationship is the Civil Rights Act of 1964, which, of course, sprung out of that very tumultuous time in our country's history when basically, in particular parts of the country, the races literally were at odds with each other, and this goes way back to the founding of our country and the Civil War, and states simply were not treating our fellow citizens equally, and the federal government needed to get involved. And one of the major pieces of legislation that came of that was the Civil Rights Act of 1964, and it did a number of things that are still with us today. It created the Equal Employment Opportunity Commission, which is a federal agency which is charged with enforcing Title 7 of the Civil Rights Act of 1964, which basically deals with prohibiting employment discrimination. And of course, in its infancy, this act was primarily put into place for racial issues, but as we know, it has evolved to include many other things. When we talk about employment discrimination under the Civil Rights Act of 1964, we're talking about treating employees or job applicants unequally on the basis of their race, of their color, of their national origin, their religion, their gender, their age, their disability, or other characteristic prohibited by federal law. So when we are treating somebody different based upon who they are rather than what they have done, that can potentially become problematic. Title VII of the Civil Rights Act of 1964 also can be enforced by private civil actions brought by employees and applicants who believe that an employer may have discriminated against them. So not only is the Department of Justice authorized to pursue these actions, but so too are our individual citizens who believe they have been wronged by an employer. And that is important because we have had different justice departments under the Attorney General who have put more of an emphasis on this or less of an emphasis on this depending upon their politics. And it's unfortunate that this is a political issue, but it is. One of the things that the Civil Rights Act of 1964 requires is that folks exhaust what are called administrative remedies. And so before an employee or an applicant can file a suit, they have to go through the Equal Employment Opportunities Commission's administrative process, which is to file paperwork and have hearings before the EEOC and await for a right to sue letter from them. But once that's accomplished, then they can go right into federal court and sue. And again, the applicant or employee can only file suit if the Equal Employment Opportunity Commission investigates the claim and they themselves decide not to file a suit, then the employee can do that directly. All right, when we talk about, what is discrimination? When do we have to worry about potentially running afoul of these laws? And discrimination can occur when we have disparate treatment. And disparate treatment is defined as the intentional discrimination by an employer against an employee or applicants who are members of a protected class. If I have brown hair, that does not create a protected class for me. If I have 6 fingers, that may not be a protected class. But when we talk about protected classes, we're talking about people's race, people's national origin, people's gender, whether they are so disabled that it creates an issue. And so to prevail on a disparate treatment claim, a plaintiff has to show the following things. First of all, that he or she is a member of a protected class, that they are Hispanic, African American, female, that sort of thing, that they applied for and were qualified for the employment. So they had the educational training, they had the experience, whatever the requirements of the job were, that they were rejected, demoted, or terminated by the employer, and that the employer subsequently filled the position with a person not in a protected class. This is really difficult for folks in HR and hiring, because you have to be very cognizant and really document why you may have hired somebody who's not in a protected class over somebody who is in a protected class. And that doesn't mean that just because you're in a protected class you get automatic preferential treatment, but the person doing the hiring better have a pretty good and clear articulable reason of why they hired the person in the non-protected class over the person in the protected class. Then you look to see, is there disparate impact? Practices or procedures which, although not intentionally discriminatory, have the effect of discriminating against members of a protected class. So, are you sort of implicitly biased against people? And that is a difficult thing to figure out and really requires some soul searching. But do you look back and say, gosh, everybody that we hired was not a member of a protected class? What are we doing here? Why does our workforce all look alike? In other words, and then the EEOC has what's called the 4/5 rule. And basically, they say there that they will deem a challenge, practice, or procedure to be discriminatory if it results in members of a protected class being hired, retained, or promoted at a rate less than 4/5 of the rate for the group with the highest corresponding rate. So that tries to make objective a relatively subjective sort of determination. All right, when we look at race, color, national origin, and religion, race, obviously, you can't discriminate against somebody based on their race with regard to hiring or promoting employees, employment conditions, or benefits. That is simply illegal. Again, most employers who engage in these practices are not that overt, and so there really takes some digging sometimes. Color or national origin. You can't discriminate against somebody based on the color of their skin or where they come from with regard to hiring or promoting employees, unless, again, the procedures have a substantially demonstrable relationship to realistic qualifications for the job in question, and that is a very high standard to overcome. Discrimination against employees on the basis of their color or national origin with regard to employment conditions or benefits is illegal. In terms of religion, employers are required to make reasonable accommodation to their employees' religious beliefs unless doing so would cause undue hardship for the employer's business. So what about the case where you have a fast food restaurant and one of the employees is Muslim and wants to wear their headgear? Is that something that the employer needs to make reasonable accommodation for? And there'll be a problem in the homework that deals with that particular case. An employee's religious beliefs need not be based on tenets or dogma of a particular church, sect, or denomination as long as it's sincere. So what this tells you is that even though this person may not be a Catholic or a Jew or a Muslim or a Methodist or whatever, if they're a Scientologist, if they're they believe in the Church of the Flying Spaghetti Monster, again, as long as their religious beliefs are sincere, it may need to be something that's accommodated. All right, what about discrimination in terms of somebody's gender? Well, again, the federal law prohibits employers from discriminating against people on the basis of gender, classifying jobs as male or female. In other words, flight attendants need to be females. Truck drivers need to be males. We used to have that sort of in this country, but not anymore. One of the responsibilities of my job is that I run a 24-hour-a-day, 7-day-a-week secure detention facility for juveniles, and we have to worry about staffing that. And we have certain ratios that we need to have, and sometimes when somebody leaves and we're looking to hire an applicant, we need that applicant to be male or female, and just so we can preserve the ratios that the law requires us to have in terms of having the applicant, the correct gender of staff available to deal with the kids that we have. And so sometimes that can be a little tricky and problematic. You can't advertise jobs in the help wanted column designated male and female unless the employer can prove that the gender of the applicant or employee is essential to the job in question. Again, that's a very high bar to reach. What about pregnancy? Federal law requires employers to treat women who are pregnant, who have recently given birth, or have a medical condition related to pregnancy or childbirth, the same as any other employee who is temporarily unable to perform some or all of their job functions. I can remember, and this was back in the early 80s when I was finishing law school and looking for my first job, and talking to some of the female friends that I had that were in law school with me, and their experiences going out to interview for jobs. And even in 1983, they were being asked, what are your intentions regarding getting married and having kids? Clearly illegal. And that was being asked by by lawyers. So even though we've had these laws in place for some time, sometimes they don't always get put into practice the way we would want to see. Equal Pay Act. Federal law prohibits gender-based differences in wages paid for equal work on jobs whose performance requires equal skill, effort, and responsibility under similar conditions. Now, we all know that there is a gender gap in this country in terms of pay, and that women make less than men. That's not a good thing. That's something we need to correct. It is against the law, but again, proving that and getting it into court can be difficult at some times. And the Paycheck Fairness Act of 2009 clarified some of the defenses that are available to employers that they can say if their female personnel is making less than their male personnel, and you can read about those in the books. And then there was the Lilly Ledbetter Fair Pay Act of 2009, and this was in the news some lately because people were wanting to undo it. But it clarified that wage discrimination claims are handled under federal law, and clarified that the time frame for bringing a lawsuit is 180 days from the last act of discrimination, not the date that the discrimination began or was discovered. So, that can make it harder or easier to prove those cases depending on the circumstance. All right, what about constructive discharge, where you've not really been fired, but you want to get rid of an employee, and so you just make life as miserable as possible for them until they just finally quit. And so, as noted here, constructive discharge occurs when an employer causes an employee's working conditions to be so intolerable that a reasonable person in the employee's position would feel compelled to quit. And so, to establish a case of that under the Civil Rights Act of 1964, Title VII, you need to prove that there are intolerable working conditions. Your office was moved into some moldy corner of the basement. That the employer knew or had reason to know existed but failed to correct within a reasonable time. And in many cases, the employer's discriminatory policies or practices causing intolerable conditions or made the employee's resignation reasonably foreseeable. So again, you've got to prove that your boss had it in for you, sort of, that they didn't fire you, but you got the crappy shifts all the time, or you got the crappy office, or you got the worst tasks, or were given the worst support staff. If you can show how all that comes to a point of, it's pretty clear that this outfit was wanting to get rid of this employee, you might have a case for constructive discharge. But I will just tell you that under the recent administration that we have, it is going to be harder and harder to prove these kinds of cases for employees. Pro-business laws and repealing some of these regulations will make it more difficult for employees to prove sex discrimination, age discrimination, constructive discharge, and things of that nature. All right, well, let's talk about sexual harassment, because even in 2017, sexual harassment continues to be an issue. And you would think that with everybody having to go through training, seminars, and awareness of sexual harassment, it still exists. Just 2 weeks ago, I had to deal with an employee involved in a sexual harassment situation. So even in 2017, this stuff goes on. And again, remember that sexual harassment isn't really about sex so much as it is about power. We often think of sexual harassment of, the boss, the male boss chasing the female secretary around the desk and at the office, and we're saying, hey, if you have sex with me, you'll get this promotion and that kind of thing. And and that certainly is part of it, but it's really more about power, and the power that the supervisor has over the employee. And and sexual harassment can occur between a male and a female, a male and a male, two females. It doesn't really matter what the constellation is. It can exist. And so employers are generally going to be liable for sexual harassment by supervisors, regardless of whether the employer knew of the harassment or whether the employer suffered any adverse job or the employee suffered any adverse job consequences. So if you've got a supervisor engaged in sexual harassment, the company is going to probably be on the hook for that. To hold an employer liable for a supervisor's sexual harassment, the employee has to prove that the supervisor took a tangible employment action, failing to or firing, failing to promote, that kind of thing against the employee. So, you're sexually harassing somebody, they don't comply, so you fire them, you fail to promote them, you had to suffer some sort of adverse consequence. An employer can avoid liability for supervisory harassment by proving that they've taken reasonable care to prevent and correct promptly any sexual harassing behavior, and the employee suing for harassment unreasonably failed to follow these policies and procedures. Again, if an employee comes to an employer and says, hey, my supervisor's making sexual overtures to me, is telling dirty jokes all the time, and the employee or the employer takes reasonable steps to prevent that, separates the two of them, assigns one to one part of the building, the other one, and yet the employee keeps coming around the supervisor, that may limit that employee's ability to hold the company liable. What about coworkers? Where that coworker is not in a position of power over the employee, but they're equal coworkers. In that case, employers are generally liable for sexual harassment only if the employer knew of it or should have known about it, and then failed to take steps. So, if you're working for a company and somebody discloses that they're being bothered by a coworker, you better do something about it right away and document that. What about non-employees? I mean, what if you've got a third party coming into the office who is, a supplier or a supplier's representative, and, they're always telling crude or dirty jokes to, the receptionist or things of that nature. Are you responsible for that kind of behavior on the part of somebody who doesn't even work for the company? And generally not. But you can if that person says, hey, every time this guy comes in, they are touching me in an uncomfortable manner, or telling me dirty jokes, or asking me out, and I don't want it. And you tell your employer that. I think that creates a duty on the part of the employer to take some steps to maybe separate you from that person, or maybe even contact that person's employer and let them know what's going on. All right, in terms of sexual harassment, historically we've talked about two kinds. We've talked about what's called quid pro quo, which is where you get a promotion, you get better assignments in return for sexual favors, or you get fired or get terrible assignments if you don't comply. That's quid pro quo, which basically means this or that. And then we had what's called hostile working environment, and I really think this is probably more common these days, but that's where you have people who are, again, cussing all the time, telling dirty jokes, having pin-ups in their office, just sort of creating this environment that's sort of hostile to people who don't want to be around that kind of stuff. And so both of those are kinds of sexual harassment that an employer can be responsible for. Again, and this is no great news. Sexual harassment can occur between members of the same sex. Not a big deal. What about online harassment, where somebody sends sexually offensive emails or pictures or things like that to others, using working equipment? I don't know. That's a tough situation. I think if you're at the office and you're using work equipment to send this stuff, I think you may be on the hook as an employer. What about if that employee goes home and is sending the same stuff on his or her personal computer to somebody else on their personal computer, but at the office they're fine? Does that create a cause for sexual harassment? And I'm not sure what the answer to that is right at this time. All right. As our population ages, and as baby boomers, which I am, kind of came in at the tail end of the baby boom, get older, we are seeing more and more cases of age discrimination, where somebody is discharged or not promoted or given duties based upon their age. And it used to be, you hit 55 or 60, and you retire, and then you die a few years later. But given medical science and things of that nature, today that's not the case. We've got people working into their 70s and their 80s. They are still just as productive. Maybe they can't lift as much, but in many cases they can still be productive employees. And so, but we're going to see more cases of people being terminated based on their age. Sometimes it's because hey, we can hire somebody new cheaper than this person who's been around for the same amount of time. So you can have employment discrimination on the basis of age against persons 40 years of age or older. Now, 40 doesn't seem that old anymore, but that's sort of the threshold that you look at. And what about mandatory retirement for non-managerial employees? You have to retire when you're 60. Those aren't going to stand so much. You have to be a member of a protected group, and you're qualified for the position for which you were discharged, for which he was denied employment, or to which he was denied promotion. And, going the wrong way. There we go. They were discharged, denied employment, or denied promotion under circumstances creating a reasonable inference of discrimination. So again, that you applied for this promotion, you applied for this job, but somebody younger was hired, even though you were as qualified as that younger person. So and again, this can apply to both the federal government, and it can apply to states as well. All right, what about if you have a disability that interferes with your ability to work? Well, along came the American with Disabilities Act, the ADA, and that is a federal law that prohibits private employers from discriminating against folks who have disabilities. And again, these are issues that arise all the time. I had to deal with one of these issues just not too long ago as well. But in order to prevail, an ADA plaintiff has to show that at the time of the employment decision, they first had a disability. And we could spend hours talking about what disabilities are, but is weight a disability? Is height a disability? Is being an alcoholic a disability? Is being a drug addict a disability? All kinds of interesting cases on that kind of stuff. And that they not only had a disability, but they would have otherwise been qualified for the position from which they were discharged or not hired on the basis of that disability. And again, so you have to show, somebody, had mobility issues. Were they not hired or promoted based on that? Somebody couldn't see or couldn't hear. Were they denied a promotion, or were they not hired because of that? If you have a disability, the ADA requires that employers make reasonable accommodation to I'm skipping here. First of all, the ADA requires employers to provide disabled employees the same health insurance benefits as their non-disabled coworkers. That only makes sense. Again, here we go. So the ADA defines a disability as a mental or physical impairment that substantially limits one or more major life activities: breathing, speaking, seeing, that kind of thing. Prior to 2008, courts held that correctable conditions such as myopia, diabetes, or epilepsy, or repetitive stress injuries, carpal tunnel, and that kind of thing were not disabilities under the ADA. Today, in 2008, Congress amended the ADA to state that employers may not consider mitigating measures or medications when determining if a disability exists. So in addition to having a disability, there has to be a record of it. The ADA does not require employers to hire or retain applicants or employees whose disability constitutes a direct threat to the self or safety of coworkers or customers. So in other words, if somebody is applying to be a bus driver and they can't see or hear, that could be a potential issue. Employers need not hire or retain applicants or employees who currently abuse drugs or alcohol, or however, an employer may not refuse to hire somebody who in the past may have been a drug addict or an alcoholic. So if there is a disabled person around on the payroll, the agency or the law requires that reasonable accommodation be made. And what that is that if an otherwise qualified disabled job applicant or employee can with reasonable accommodation perform essential job functions, then the employer must make those accommodations. And so these are some of the accommodations. Installing wheelchair ramps. So, if somebody is perfectly qualified to do the job, but the office is such that they can't get a wheelchair in, because there's stairs leading to the front door, they may have to, put in a ramp. And of course, we're seeing more and more businesses and federal government and state government in particular, whenever remodeling is done or new construction occurs, they always have to be built according to ADA standards. So, establishing flexible working hours for that person, modifying job assignments, reassigning non-essential functions to somebody else, creating and improving training materials and methods, unless doing so would create an undue hardship for that employer. Undue hardship is defined as a situation where it would cause a significant difficulty or expense. So if I'm a private employer and I have somebody, who can't get around as easily as others, and it would cost hundreds of thousands of dollars to modify my small business, which would cause me to go bankrupt, that might be an undue hardship. All right. Well, what are some of the defenses to discrimination in the workplace? And there are a few, and you can read these at your leisure. Generally speaking, my opinion anyway, folks should not be discriminated against in the workplace based on any of the factors that we have talked about. But these here, such as business necessity, bona fide occupational qualification, seniority, after acquired evidence, these are things that employers will use sometimes to defend themselves in discrimination lawsuits. Okay, well, really a quick discussion of that, and we will visit with you again in our next discussion. Take care.